The appellants do have the right to reserve up to 5 minutes for rebuttal. So when you get to the podium, please, after introducing yourself, let us know how much time you wish to reserve, and we will program the clock accordingly. Are there any introductions or announcements this morning before we? Mr. Kozlowski? Good morning.
Good morning, Your Honor. It's been a while since we've appeared before the court.
I guess our luck ran out. No, we're glad to see you again, Mr. Kozlowski.
We'll see how much luck we have later.
Okay.
I have the pleasure of introducing to the court my colleague Shelby Dotson.
Hello.
Ms. Dotson is a graduate of Goodpasture High and later, more recently, of course, a 2016 graduate of Belmont Law School. She worked for a couple of years with Tennessee Justice Center and has been with the Legal Aid Society since 2018. Most recently, she was promoted or named the managing attorney of our Nashville office. This is her first appearance. Appreciate it if the court would welcome her.
All right. Thank you, Mr. Kozlowski, and we are pleased to welcome you, Ms. Dotson.
Thank you.
Thank you. All right. That doesn't mean we won't ask bone-crushing questions, but... All right, call the first case, please.
Richard A. Peterson versus Margaret E. Georgiades et al.
Well, speaking of one's luck running out, Mr. Kelly, it's been a long time. Good to see you this morning.
Yes, sir. I was going to, I don't know, I kind of chuckled at myself because if you'll notice, as lawyers who've been in practice for a long time, they let their beard grow and their hair grow in the back. And I said that's always the case, and they've been practicing a long time. But I see that Judge McBride has the same, he's done the same place.
Well, when I get as old as you and Judge McBrayer, I might do the same thing.
I don't think I'll need to reserve any time.
No time? All right, sir.
I'd like to, of course, introduce my partner, Gwen Kelly Smith, as well.
Good morning.
Actually, she's the brains of the situation.
Well, I'm glad to hear that.
That's right. This is a case where Ms. Georgiades took care of her brother, Mr. Peterson, for years. He had a substance abuse problem, and he didn't take any responsibility with regard to himself or his properties. And she got involved and been helping him over the years. In fact, in 2006, I believe, a power of attorney was prepared. It was an expensive power of attorney under 34-6-110A. And she, in fact, saved him from giving a house away at one point in time. And then she found this property where they are now, and they were able to negotiate the purchase of it, which was just in Mr. Peterson's name at the time of the purchase. But she handled it all. She signed the deed and all that. Then in 2010, they were concerned because of the fact that he was not responsible and could be easily duped and influenced, that he agreed that she should be conveyed half interest in the property. And that was done primarily at that time to protect him. But also at that particular time, she undertook to start paying the taxes of her personal funds. Not all the taxes, but a lot of it. She also, along with her husband, made a lot of improvements to the property to make it habitable. And so this went on from 2010. And she did not realize, of course, at the time when the quitclaim deed was drawn, that she did not have the authority to do it. She thought, of course, under the terms of the power of attorney, that she could deal with real estate. She wasn't aware that there needed to be a provision in there where she could gift herself.
It was gifts for no consideration.
For no consideration, that is correct, and she was not aware of that. So
is that a conceded point?
Yes, it is.
Okay.
It is a conceded point. So, but anyway, during that period of time, as I said, over the course of the years, that they would go out there and they would help and maintain the property to see that the insurance was paid. And even to an extent that where a joint account was set up between the two of them so that she could actually take care of his finances because he just was not going to. And everything went along just fine. And the key here, even though with the motion summary, the key here is the fact that he acknowledged this fact to his brother. He acknowledged the fact to his neighbor, and he acknowledged the fact to one of Ms. Georgiades' friends. He said that he had given her half interest in the house. He consented to that, and he approved that. And of course, everything, what's important here, everything was out in the open. Everything that was done. Either he knew about it.
I want to understand the scope of the concession here. She was not acting in her capacity as having a power of attorney when transferring title or when executing the quitclaim deed?
This particular deed, or are you saying?
The 2010 deed. That when she says in 2010 when
No, she signed it as power of attorney. She signed the quitclaim deed and she signed it as power of attorney.
Okay, and so your argument is that she was within the scope of her power of attorney with regard to the 2010 transfer?
Well, she was in the scope that she could deal with real estate. What was not in the power of attorney is the gifting provision to herself without consideration. That has to be stated specifically in the document. If the person given the power says that the power of attorney can gift themselves without adequate consideration, that was not in there. But otherwise, the expansive language of 110A says in there that she could do anything I could do myself. That's in the power of attorney. So the question comes down, and the court, is whether or not the transaction in 2010 was void ab initio, which means it didn't happen, or is it voidable? We maintain that it is voidable. And what I'm saying is anytime after that, after Mr. Peterson, if he had changed his mind and says, you did not have the authority to do this, and I want the property back, it was in his authority, in his control to do that had he wanted to. But as I said, there were 10 years where they took care of the property, 10 years that he lived there, 10 years where he acknowledged to various individuals that he had given half interest of this property to his sister. He even told his niece that he intended to leave his share of the property to her at his death. So everything was going along as it should be until Mr. Peterson married Miss Peterson. It was at that time that he decided that he did not want to give her that, or he did not want her to remain on the title to the property. It was at her urging, not his, that this took place. And the deposition of Ms. Georgiades says that. In fact, Ms. Georgiades was so put out with this that she, as the power of attorney, conveyed the other one-half interest to her daughter. Well, as it turned out, Mr. Peterson says, I did not authorize that, and that deed was reversed. It was conveyed back to Mr. Peterson. And that was certainly within the time frame. But our argument here is that I think that you need to consider what was done, when it was done, and the fact that under the case law, the courts dealt with, of course, breach of fiduciary obligations in estates and that type. Here, Mr. Peterson was living and is living. It's not a situation where he was not at a point he died, and so he couldn't come in and contest the fact that that breach was something that he did not authorize. And what we're saying simply here is that even though he didn't sign the deed, because he didn't sign any of the instruments, never did sign the instruments, it was up to her to do that, he assented, he ratified what she did, he consented to it, and he did it with full knowledge. And it seems to me from his actions and from his statements that should bind him to make it a voidable transaction rather than a void transaction. And through our research, I am not aware of any case where it involved an estate in breach of fiduciary duty where the court said that the transaction was void in ab initio. It's always a situation of whether or not the transaction should be voided or set aside in many cases that comes before this court. So our position is simply that from his actions, from his discussions, that he authorized the attorney-in-fact to convey one-half interest of the property to her, and he had no objection to it. It did not come up until he married his wife, and she says that she wanted it undone. And we're saying because of the fact that it had been 10 years, that statute of limitations bars him from having to set it aside. We think the statute of limitation does apply in this situation because it's a voidable transaction, not void in ab initio.
Counselor, some concerns in terms of the idea of authorizing or condoning in the context of a power of attorney situation, where we have somebody who is struggling to manage their own affairs, turns to a relative to assist them. There's limitations within that power of attorney provision in terms of what they can and can't do. And your argument essentially is, well, they can authorize beyond the power of attorney and you can act in the scope of power of attorney. We're talking about somebody with limitations in terms of their capacity and ability that's looking for help. And shouldn't we be wary of the idea of authorization in that type of context becoming a basis for somebody to act in that power of attorney role? Or am I missing something there?
Well, he did look to her for help and assistance, but he was not rendered incompetent by any means. You know, and she kept him fully informed. It's not a situation where she was going behind his back to do anything. He was always kept informed as to what was happening. He wanted her to do certain things in terms of keeping up with her finances. He invited the fact that the improvements were made to the house, and he made no objection to it whatsoever. So what we're saying is, in his mind, what she did was outside the scope of that particular power of attorney. It was a breach. But at the same time, he authorized it, not only at the time the deed was recorded, but subsequent to that, because he told people, says, I've given half of this house to my sister. So he's acknowledged that it was done, and it was done voluntarily. He never did object to it. So, I mean, it's the situation, in these other cases where the powers of attorney convey the property out from the estate, you know, without the knowledge, or the decedent died after it was, and then the court set it aside because they said it was a confidential relationship and abuse of power. Here, everybody was living and is living. He had the opportunity at any time, Judge, to set that deed, if he wanted to say, I don't want you to have this interest anymore. But he did not, and he has not until he married Miss Peterson. And in the depositions, it states that Miss Peterson made that clearly known to Miss Georgiades. And so until then, everything would have been fine. And if the question comes up, well, then what if Miss Georgiades and Mr. Peterson sold the property? If it was void in obitio, then that deed would not be a good deed. And a lot of times when that happens, unless someone's checking the title, they see the power of attorney, then they may not question this. So the question comes down to whether or not, when you say void in obitio, you've got a problem. We're just saying here that it could have been a voided transaction if he decided he wanted to void it. Otherwise, it was valid on its face until he decided to void it. And we're saying because of that this 10-year statute of limitation does run on a transaction that could be voided, but was not voided. And it's just as plain forward as that. I mean, that's just what it is. It's because of what he did and what he said that I think changed the transaction, even though she did not have the power in that power of attorney to gift herself without out consideration. He had acknowledged it, he acknowledged it, and he went forward to state to people that he knew that he had conveyed that, and he did that with his consent. And I do think, and you know.
So what do we do with the case law then that says that a deed executed outside the authority of a power of attorney is null and void? I mean, was that a misstatement of the law in our cases?
Well, I wouldn't say that's a misstatement of the law, but looking at anything, the courts, a lot of times if they found that it's outside, they'll set aside. But that's different from saying that it's void in obitio. And there again, I do think the character and the actions of the power of attorney, it's kind of like an agency. He acknowledged what was done. And so I think that at that particular time, he consented to and he affirmed what she did. And that's the reason I'm thinking that it's a voidable transaction that could have been set aside, but if he did not, I think it's within the statute of limitations that he did. It was, more than 10 years after this objection was raised.
Anything further, Mr. Kelly?
No, Your Honor.
No, any further questions? All right, thank you, sir.
Thank you.
Ms. Dodson, this may appear to be a little bit like law school since you're appearing before one of your professors.
It
I
may.
hope you don't feel any extra pressure there.
I observed Judge Eastman last month on the
Oh,
bench,
okay,
and
never mind.
it did
Okay.
feel quite familiar. I was having flashbacks.
All right.
Good morning. May it please the court. Again, my name is Shelby Dodson, and I, along with co-counsel David Kozlowski of the Legal Aid Society in Middle Tennessee and the Cumberlands, represent Mr. Richard Peterson, who's the plaintiff appellee in this case. I want to pick up where Judge McBrayer just left off, which is with this case law that talks about void versus voidable for the statute of limitations purposes. The two specific cases that we cite in our brief are Heinemann v. Moore, that one's found at page 25, and also Bottorff v. Sears, which is at pages 26 and 27. In the Heinemann case, this court held that, quote, a deed of trust executed by an attorney in fact is null and void to the extent that it exceeds the attorney in fact's authority. We just had a concession that the action taken at bar here was outside of the power of attorney's authority, and
Yeah, I'm concerned though about what the impact of extending, well, first of all, let's talk about the void ab initio doctrine. I mean, I always thought that just applied with statutes or ordinance, but you're saying it applies to deeds also. Do you have a case that says that?
yes, Your Honor, that's the Bottorff case.
Okay.
Bottorff v. Sears.
And so that means when I'm looking at a chain of title, I've got to go back to the history of mankind to see if there was any deed executed by a power of attorney, and then review that power of attorney, because there's no statute of limitations for setting that aside. So aren't we basically talking about changing real estate law here?
I don't think so, Your Honor. I think it's interpreting the power of attorney statute and, like Judge Eastman said, protecting vulnerable people from these kinds of gift transactions.
So, but our Supreme Court has said that the void ab initio doctrine has limited validity now in the Cumberland case. So this sounds like it has really a lot of validity in Tennessee if this applies to the deed of trust situation.
Yes, Your Honor. The Bottorff case, I believe this court quotes the void ab initio doctrine is alive and well in Tennessee, I think.
Yes, but I mean, the Supreme Court in Edwards has spoken more recently on that, and they went back and cited Cumberland Capital for the point. So setting aside for a second, I guess, the concept that a deed of trust could be void ab initio, what is the effect of reliance on such work as like, because the Supreme Court clearly recognized that if there is some sort of detrimental reliance, that could impact the statute of limitations analysis. Don't we have to worry about that, particularly with real estate where someone might have built a home on a piece of property?
So the Heinemann case does have a detrimental reliance, a bona fide purchaser argument, and the court ultimately went the other way in that case because of the detrimental reliance of a bona fide third-party purchaser. Those aren't the facts we have at bar here.
What case was it that dealt with detrimental reliance?
That's the Heinemann v. Moore case.
Okay, thank you.
That one's at page 25 of our brief.
Thank you.
Yes, Your Honor.
Of course, in that case, we went back to the middle of the 19th century to find support for that proposition, which, you know, it's not unlike courts, I suppose.
Counsel, with regard to the response to plaintiff's statement of undisputed facts, there's a number of factual assertions contained therein that reference ideas along the lines or facts along the lines of that there was authorization, that there was essentially consent. The trial judge's order doesn't seem to have really weighed in on that. It seems to have looked at this as, was it within the scope of the power of attorney or not? Is that enough to create a sufficient factual dispute that this really should go back and that it was error to grant summary judgment in this case based upon the facts that are asserted in the response?
No, Your Honor, those facts are not material. In our brief, we go through some procedural problems under Rule 56.03 with the way those facts were presented. But the bigger issue is that they're just not material based on the statutory analysis. 34.6.110 lays out how an attorney, in fact, can make a gift of a principal's property. And there's three ways that can be accomplished. The first one is gifts that are consistent with the principal's history of gift making. No evidence of that in the record or elsewhere of any gifts by Mr. Peterson to his sister of real property, or frankly at all. The second way is more relevant to this case, gifts that are authorized by express words in the power of attorney or other writing made by the principal. So in the defendant's response to the statement of material facts, it's admitted that there is no writing in the power of attorney or otherwise that would have authorized this transfer.
Can Mr. Peterson go beyond the scope of the power of attorney to authorize additional action, though? And isn't he authorizing this transfer? And I don't trust myself with regard to this property. I'm worried about creditors coming for me. Why don't you go ahead and transfer it so that you have a half interest in the property? And can't he transfer more authority than the agreement itself provides for, or than the provisions of the power of attorney provide for in their own right?
Yes, Your Honor, he can. He must do it in writing. It can be in the power of attorney. It could be on a cocktail napkin. It has to be in writing, and that's under 34.6.110.
You're relying on the statute of frauds, or?
That's the Uniform Durable Power of Attorney Act.
Does the statute of frauds apply as well, because we're dealing with an interest in real estate?
It may, Your Honor. The third way goes back to Judge Usman's point about protecting vulnerable people, which seems to have been Mr. Georgiades' intention here. The third way under 110 that an attorney, in fact, can make a gift of a principal's property is if a court approves it. There's no evidence that Mr. Georgiades sought permission from a court to make this transfer of Mr. Peterson's property to herself. Additionally, she could have, again, either party could have put his intention in writing, or she could have sought a conservatorship if that was the protective action that was required for Mr. Peterson's benefit. None of that happened here. Unless there are any further questions, I think I have covered.
Hearing none, thank you, Ms. Dodson, and thank you, Mr. Kelly, for your arguments. This is a more intriguing case than I realized when I first read the briefs, based on the questions and arguments. Thank you very much.
Your Honor, may I approach?
Yes, sir.